The reason that we're here today is because this defendant, Donna Adelson, was part of a conspiracy to hire a hitman to kill her former son-in-law, Dan Markell.
They put her at the top of this pyramid. She's the matriarch. She's the matriarch mastermind behind Danny being killed, and they don't have evidence of that.
I think my mom thought my life in Tallahassee wasn't good.
Had they decided when they were coming back from Vietnam?
They were undecided.
We are counting down to the closing arguments, less than an hour away from court resuming in the murder trial for Donna Adelson. On the schedule, closing arguments, but we're wondering, could there be a last-minute change of plans? Plus, the 75-year-old defendant said she would not take the stand, but she seemed unsure about that decision. Could she change her mind this morning? It's certainly possible. Also this hour, we've got some brand new autopsy results coming in for the infant found dead in a closet. A University of Kentucky cheerleader is the accused. And we've got a big ruling to talk about in the Gilgo Beach murders case. The judge allowing in DNA evidence. So what will this mean for the defense going forward? While Rex Heuermann's attorney joins us live. It's all coming up next for you right here on Opening Statements. Good Thursday morning to you, my friends. Or should I say happy Friday Eve? That's what we like to say around here at Court TV. I'm Julie Grant, and this is Opening Statements, the show where we get you all warmed up and ready to go for the big day ahead on Court TV Live. And oh, what a big day it's going to be. Let's kick things off as we always do. Grab that cup of coffee. It's time for my opening statement. All she did was talk, 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 until it was time to talk, and then she decided she's not going to talk. Mama Donna Adelson told the court she is aware that her life depends on her decision to take or not take the stand in her own defense. She opted not to do so, and I think she might regret it. Yes, it's true that defendants rarely help themselves, but there are exceptions to every rule, and I have seen it happen. You know, sometimes they surprise all of us and they help their cause. I see Mama Donna's case as one of those rare exceptions. I think she should have rolled the dice. I mean, what has she got to lose? She is 75 years old. She's looking at potentially life in prison if she's convicted. She can throw herself at the jury's mercy with 4 other convicted killers to blame. As the defendant, all you really need to do is convince one juror that there's too much reasonable doubt to convict. And if you get that one juror to believe you, well, you're off to the races for at least a mistrial. And maybe the state rethinks its case. Or even better yet, if you come off truly believable and sympathetic, you can potentially walk. Or in Donna's case, fly to Vietnam. Donna took the safe bet. And I certainly can't fault her for that. But I think that this trial has gone so badly for her that she might one day regret passing on the opportunity to talk to the jury and possibly save herself. That's my opening statement. Let me know if you like it. Right now, it's time for your daily docket.
I was afraid because I knew bad things happened. And I was afraid that because I was an informant, things would go wrong. Things would happen to me.
In Tennessee, we've got the man accused of killing 4 family members back in court today. Austin Drummond's preliminary hearing kicks off at 2 p.m. Eastern. In Ohio, we've got defendant Bianca Ellis. Remember her from the toddler stabbed murder case? Well, she's got her final pretrial hearing before the trial date will kick off. Court's going to start this morning at 8:30 a.m. And in California, we've got parents Jake and Rebecca Harrow. They've got their arraignment today. They're accused of murdering their still missing 7-month-old baby Emmanuel. Their hearing is going to kick off at 11:30 a.m. Eastern time. Right now, I want to turn to our top story for you this morning, and that is the closing arguments in Mama Donna's murder case. Court's expected to start up 8:45 a.m. Eastern. This judge is incredibly prompt runs a tight ship, and as soon as they're ready to go, we're going to take you in there live. So let's talk about what we can expect. The defense rested after Donna decided she would not take the stand, but really seemed like she was struggling to make that decision.
Concerning those rights as to whether you will remain silent or whether you will testify, have you made a decision concerning this matter?
I haven't. I'm not prepared to make that decision. This decision affects the rest of my life.
Mrs. Adelson, you're in the same position as every other criminal defendant who faces trial. Ultimately, you must decide whether you will testify or whether you will not. I cannot make you testify. Your attorneys cannot make you testify. But ultimately, you must choose whether you will testify or not.
I don't have to choose. I was hoping that we'd have some time to speak to my attorneys.
This has already been discussed, ma'am. What is your choice?
So after a sidebar, Donna ultimately came to the decision that she would not take the stand.
Mrs. Adelson, the question remains, as it relates to your right to remain silent and your right to testify, what is your decision concerning these two rights?
This time I don't want to testify.
So was Donna's decision not to take the stand the right one? And will she change her mind? Let's bring in our legal eagles. So happy to have on the show this morning, Michael J. Brown and John Phillips. Good morning to you both. All right, so let's tackle these questions in turn. First, the decision not to testify. Is it a good decision? Michael J. Brown, what do you say?
Good morning, John. Good morning, Julie. I'll give you the answer on Monday morning because we don't know until we get a verdict from the jury. It's all 20/20 hindsight. Two things I love. I love this judge, and I loved your opening statement. You were spot on, Julie. It's the most difficult decision that we as trial attorneys face. And the clients always look to us for our advice and our counsel and really follow what we suggest. She was struggling. I think that was a genuine struggle for her as to whether or not she was going to testify. But, we've talked about the pitfalls of testifying. The defense attorneys do their thing. They cross-examine. They do the best they can. And in one swoop moment, the defendant on the stand can have all that unraveled by something she said. So I think, and we'll get into this in a bit maybe, I think they got out everything they wanted without having her subjected to cross-examination.
Great points, Michael. John, your thoughts on her decision not to testify. Was it a good one?
I agree. Get ready for this, okay? I am not calling Donna Adelson an ogre, okay? Under no circumstances. But as Shrek once told us, ogres have layers, onions have layers. This cross-examination would have a lot of layers, fleeing the country, all of the questions that she'd have to answer. I think she did a great job in the fact that she preserved a possible appellate issue right there in Tallahassee, Florida Supreme Court, DCAs. Did I waive? Did I not waive? Did he ask me this morning whether I waive? But the judge has been good. He's got it pinned down. He's entitled to find, the right schedule. But this cross-examination would have so many layers that even Shrek would be humbled.
Oh, John, we appreciate the words of wisdom from you and Shrek. So let's tackle the other questions. So it's possible she could change her mind. So let's walk through what may happen. Let's just say hypothetically, and we don't know here at Court TV, but just based on the way she vacillated, I know I'm thinking I would not be surprised if she comes into court this morning and her defense attorney has to ask permission to reopen their case. Michael J. Brown, what do you think? If she decides that she wants to testify, how do you see this playing out?
Yeah, it's a fundamental right, Julie, even though she waived it and the judge did the inquiry. If she decided before they went to closing arguments that she wants to exercise her right to testify and present her testimony, any judge is going to let her have that opportunity because it's a fundamental right. Yeah, she can do it. I don't think she would. I think she is set I don't think it would be a calculated thing where they had this all along and they're trying to throw the prosecution off. I think it was something, she was sitting in a jail cell last night and probably struggled with this and probably didn't get sleep and thought about it back and forth. So is it possible? Yes. Is it likely? I don't think so, because I think this was a game decision made by the attorneys along with her, and they were firm and committed to not testifying at the end of the day.
Michael, thanks. John, tell us, what do you think? What do you think? Should she change her mind tomorrow, or does she change her mind today, rather?
I don't. I do think the judge should probably ask and make sure that she's sticking with her non-story. The Fifth Amendment, important Bill of Rights, right against self-incrimination. I think she made the right call. I think her lawyers were probably pushing her in that direction, but as the mastermind, as the matriarch, I think she wanted to tell her story, but realized that there's a lot of twists and turns within that story.
Sure. No, exactly. So let's look at one of these moments where we could tell she was struggling. And even though she's had time, her defense team was saying they didn't have enough time to make this decision.
What are you asking for?
I'm asking for additional time to be able to go through all of the testimony and evidence with our client so that she can make a fully informed decision as to whether she wants to continue to remain silent or testify in this case.
Ms. Fulford, concerning that has been provided by the court. If she wishes to testify, we do need to go through the colloquy. If she does not, it's a simple matter. But there has been time pre-trial to prepare for this moment. There's been time during trial, and specifically, we recessed court early for you to address any issues of witnesses or whether your client would testify.
Michael J. Brown, what'd you think of that moment?
Yeah, I love this judge. I go back to what I said earlier. He is so professional, Julie, but this is not something that they're struggling in terms of the defense. They know as they went along, did we accomplish what we want to accomplish? And they'll know if they think they're going to benefit from putting her on the stand. It's really not, from the defense standpoint, from the attorney standpoint, something that you're going to decide at the very last moment. They knew going into that day, they probably knew 2 days before that they wanted or did not want her to testify. But the client ultimately makes that decision, and she may very well have given them that ambivalent feeling. So that's maybe what they're putting on the record.
Yes, I think you're right, Michael. John Phillips, what do you think? Do you think that the attorneys are advising her, look, let us handle this, don't do it, too much to lose here, we got this one, and that it's her that has the inclination to want to talk?
I think that's exactly it, Julie. I think your gut instinct is dead on as usual. And I also think that there is some gamesmanship by the attorneys to see what the judge is going to do as to whether they could possibly set up an issue for appeal here by forcing the Fifth Amendment issue, forcing the testimony to happen now. I think the judge has ruled exactly as Florida case law holds, but that's not going to stop an application for an appeal.
Right, and bingo was his name. Oh, John, I think you're spot on there that the way the attorney was wording that, I'm sure you both thought the same. Oh, she's really just, this is the groundwork, right? And you could see it being typed by the stenographer. She was saying it, that we need this time to go over all the evidence, making that plea. And as Michael said, come on, they know what the evidence is. They've been down this road many times. This is to protect the record, as you noted, John. All right, so let's show everybody one of these moments in court. This was a Mama Donna outburst moment. Here we go.
She also had a phone call with her son, who's obviously in jail here. 25-minute phone call. I personally listened to it. She very clearly spoke about a plan to kill herself using sleeping pills.
One moment. Ms. Adelson, please keep your comments to yourself. Let your lawyer argue on your behalf.
Okay, so that was at a pretrial hearing. In terms of how Mama Donna does on the stand, some of us in our newsroom were talking about that clip. That's why we resurrected it this morning. Like, ooh, is she going to have a tough time if she does change her mind and if she does want to get up there? Michael, what do you say?
They did what they did perfectly. They dressed her down. They made her very grandmotherly-like, and that's very in contrast to how she appeared prior to being arrested. So I think they're going to accomplish their objectives, again, without putting her on the stand. They got out with some witnesses about why she had a one-way ticket, so they killed that issue, at least from their standpoint. They also talked about the fact that she loved her son-in-law and she wasn't that hostile towards him. So they really got out what they could have and did without putting her on the stand, subject to cross-examination. So that's a good move.
Yeah, sure is. We'll see what happens in just a short time. Sometimes we get a court signal at this time. We don't have one yet, but I'll let everybody know when we get it. Our cameras are ready to rock and roll. As our wonderful legal analyst guests, John Phillips, Michael J. Brown, stand by for more cues, please. We're going to hit a break. Friends at home, if you want to get some more coffee, good time to do that. We're back in just 4 minutes. Here's what's coming up on Opening Statement.
Oh, Suzanne, if anyone is out there that can hear this, that has you, please, we'll do whatever it takes to bring you back.
We believe that she's not alive.
After more than 3 years, the remains of Suzanne Morphew had been found.
There's going to probably be a lot more questions now than ever because, I mean, who did it? Why?
Accused killer Barry Morphew back in court. Will he soon be able to walk out of jail? We'll talk about his recent bail modifications. Plus, new autopsy results in the case of the University of Kentucky cheerleader who's accused of hiding her dead baby.
Adelson is facing charges of murder, the death of her former son-in-law.
Now that Donna has turned into a defendant, what's next for the Adelson clan?
The matriarch mastermind murder trial. Live coverage today, only on Court TV.
Saturday nights on ION
is our night.
Let's go! Double headers every Saturday at 7 and 10 p.m. Eastern. The new Saturday Night Out is on ION all season long.
Good afternoon, Your Honor. Brandon Marshall on behalf of call number 8, Lake and Snow.
Dates are, this Friday 5th, 12th, 19th, or 26th, you want to wait time?
26th, and we will wait time, sir.
That was Laken Snelling in court on Tuesday. The University of Kentucky student remains at the center of national headlines. A preliminary autopsy report, though, is creating more questions than answers in her criminal case. So the 21-year-old is currently on home confinement pre-trial at her parents' house in Tennessee after she was let out of jail on that bond. Now, she's accused of hiding her dead infant in her closet. Court TV's Cody Thomas has more.
That was 21-year-old Laken Snelling, the University of Kentucky cheerleader, who's now been arrested after her own newborn baby was found in her closet. She arrived to court today for her first appearance and arraignment following her arrest on Saturday, August 30th. She's facing charges of tampering with physical evidence, abuse of a corpse, and concealing the birth of an infant. Lexington police were dispatched for an unresponsive infant at a home, Snelling's home, where that infant was pronounced dead at the scene. Police say Snelling admitted to giving birth and also admitted to trying to hide it by placing the cleaning items inside a black trash bag, a trash bag that also included the baby wrapped in a towel. Snelling has since posted $100,000 bond and is now under home incarceration with no ankle monitor, ordered to live with her parents. Her next court appearance is scheduled for September 26th.
It was Cody Thomas reporting that preliminary autopsy for the baby released Wednesday by the coroner in Fayette County, Kentucky. It said in part, as for the cause of death, quote, the findings are inconclusive. Extensive microscopic analyses are essential to determine the cause and manner of death. The manner of death listed as currently undetermined. The coroner going on to say, I understand the community's concern and sensitivity surrounding the death of a child. This death affects many lives in our neighboring state of Tennessee, as well as those in the Commonwealth. We're currently conducting a thorough and methodical death investigation to ensure that all facts are carefully considered. Ooh, well, quite an acknowledgement there from the coroner. And we here, as we've been poring over the facts that we do know feel like there's more unanswered questions than there are answers. Who found the baby? What was the term of the baby? How long was that baby deceased in that closet? Let's bring in our guest to talk about it. Criminal defense and civil rights attorney John Phillips is with us, and also want to welcome in retired NYPD detective. He hosts his own show on Odyssey, Rob O'Donnell. Good morning to you both. I want to start with the biggest outstanding question that you both may have as you're poring over the information that we do know. John Phillips, would you start us off, please?
Yeah, the main questions I want to know is who called police and how old was that child, to your point? You know, those are really, really important. And then you go back and look at Lakin's TikTok where she's talking about motherhood and all of the options that a girl has with like safe haven boxes and adoption. And it's just a really sad set of facts here that this is the way she chose to treat her own child.
Yes, John, thank you. Rob O'Donnell, tell us what questions are top of mind for you, please?
Again, how the baby was discovered is obviously one of the top ones here. You could see that they're focusing on, they're not charging her with the death of this child. They're charging her with the tampering of evidence and the dealing with the corpse and such like that. They're dealing with the evidence and the things they know they can prove at this point. The autopsy is going to be very crucial moving forward. This molecular structure analysis that they're going to do can basically they have to watch the deterioration of the tissue over a period of time to see if they can determine if the baby was born alive, if the baby was stillborn. But without that determination, a lot of these cases usually end up in some sort of plea deal. But with the extensive social media that a lot of these young kids have at this age that this young lady obviously had, you know, are there any things there? Her portrayal of wanting motherhood here is something that is not going to look very kindly for a jury if this does get to a jury. The other thing is discarding the baby with the cleaning supplies, with the trash. And any prosecutor is going to key in on that you took your child, your baby, it was born or not, and discarded it with the trash. So that's also not going to look very kindly come trial time.
Right, all great points, Rob. Rob, tell me, really tapping into your experience, having done so many different interviews over the course of your career with the NYPD. If you could get in a room with Lakin Snelling, if she would be willing to speak with you, what are some of the things you would ask her?
Why didn't you believe you had other options? Why did you do this? You know, any good defense attorney is gonna try and portray her and have her portray herself as, I panicked, I was scared, I didn't know what to do, I didn't have a support structure around her. So you want to lock her in. She did make statements off the top of saying that she did have this baby. So there are on the record statements before she lawyered up in this case. So you want to ask her, even with an attorney present, if it's allowed, is what's her support structure with her family? Do you live with a loving family? You know, what's the case around you to build a prosecution against? Well, you did have options. There was a big support structure around you. You didn't have to do this, and this is what you did. If they can prove that the baby was born alive.
All right. All very, very helpful points you made there. Rob, thank you. So we'll leave this Kentucky case here for now. Of course, bring you any updates as we get them. As we turn to another big trending story in the world of true crime and trial, that's the murder of Suzanne Morphew. Her husband, Barry Morphew, could be out of jail soon. So he was back in court this week after he's been indicted for the second time, accused of murdering his wife, Suzanne. On Tuesday, the judge denied his request for a bond reduction. So he's in on $3 million cash only. They wanted it to be $500,000 cash. The judge said no on that, but did make some modifications to the conditions that may allow him to get out of jail. So here are the modifications. He could potentially post through some other means that would require less money up front, including a 10% surety bond through a bail bondsman or property bondsman. Property bond, rather. Morphew's lawyer said that he could also come up with $500,000 in cash to help him get there. Wow. Okay. So we're wondering, is Barry Morphew going to walk out of jail anytime soon? John Phillips, what do you think, please?
I think he will. You know, this federal system and the state systems are trying their hardest to keep the cloak of innocence until proven guilty up until the end of a trial, the jury verdict. And so they want more people to have bond and bail, and then they've got to work with the conditions. And a $3 million cash bail is a non-starter for the 99.9%, but with some terms that would allow a cash portion if you can find the right bondsman that say, all right, I'll take your $500,000 and we're going to keep an ankle monitor and we're going to keep an in-house security person, at your doorstep, and we're going to make sure we get you to jail. I mean, to court on time. I think that's what was weighed here, and I know there was a lot of back and forth about his true ties to the community and all of that. But given how high profile this is, I don't think this is going to be somebody that finds a place to hide.
Right. I agree with you, John, on that point. Thinking back, he was charged once. We know the charges were withdrawn by the DA's office. We won't even get into that whole mess, but they were. And he didn't flee the country. He didn't get a one-way ticket to Vietnam. So, he stuck around, right? He's got kids. Rob O'Donnell, what do you think? Is he a flight risk?
I don't think he's a flight risk, but I think this is a very dangerous case. Here's an experienced subject. He's been through this before, and he withstood the questioning from prosecutors, from investigators in this case. So he's just going through this again. And with his experience in dealing with the charges being dropped the first time with prejudice, which is a good thing, there are different dynamics here because there is some forensic evidence that's found now with the bones that were recovered from his wife. But again, the autopsy on that material that was found is again inconclusive. So he's a dangerous subject because he's been through this before and he has that experience. And if he realizes if he keeps up that same demeanor that he did the first time, unless they come up with some dynamic evidence, he may just walk on this.
Yeah. Let's look at, we have time for one more clip. This was a little battle going on in the courtroom on Tuesday, and it has to do with this BAM evidence, we're calling it. So the tranquilizer drug used in hunting, okay, that was big because that was found in Suzanne Morphew's system. We know we found that tranquilizer dart cap in the dryer. The detectives found it, and that was part of the link to Barry Morphew and part of the charging. Let's listen to what was said in court.
Insofar as the indictment, Your Honor, as the court knows, that is a cherry-picked piece of narrative that has been created exclusively by the district attorney. The BAM that the district attorney mentions that Mr. Morphew had access to, I want to be clear on, was prescribed to him in the state of Indiana in 2018. Mr. Morphew has not had access to BAM since 2018.
The remains of Suzanne Morphew after an autopsy contained a chemical compound that Mr. Morphew had almost exclusive access to, tying him directly to the remains of his wife. The case in 2021 was arguably entirely circumstantial with no body. This case is very different.
Okay, so Rob O'Donnell, I want to ask you, when it comes to this BAM evidence, obviously we see the defense wants to fight to keep this out. How key do you think it is to the case of what happened to Suzanne?
Well, with this here, I think it's easy for them before a jury to say, how many of you sitting in the jury have expired medication at home? Every jurisdiction in our nation has expired medication giveaway. So the fact that he had access to this in 2018 and could possibly still have it today or still have it in his possession, I think a prosecution team can easily convince a jury that I think we all have expired medication somewhere in our closet. And to the extent where every jurisdiction has your old medication or your expired medication give-backs programs. So it is very possible and very likely that he did still have access to this medication.
Great point, Rob. Yeah, the time doesn't preclude that possibility. Excellent analysis from you both. As always, Rob O'Donnell, host of The Rob O'Donnell Show. Celebrity attorney John Phillips, thank you both so much. Here's what we're going to do. We're going to hit a break. When we come back, we've got some brand new developments to share with you in the Gilgo Beach murders case. DNA evidence not coming in, but guess what? We know Rex Heuermann's attorney, and he's got a backup plan. He'll share it next. Plus, closing arguments set to begin soon, and the murder trial for Donna Adelson. Live look at the courtroom. There she is. So we're getting ready to listen to those closings together, and we could possibly have a verdict today. The countdown is on. Don't go away.
State Police.
Yeah, there's somebody after me.
I'm sorry?
There's somebody after me.
This is a 13-year case, so as you saw, we have a great deal of information, evidence, photographs, reports.
This case is a case that we're going to try in a courtroom. The press has convicted my client without seeing a shred of evidence.
She had no...
Welcome back. This morning, the spotlight is on the Gilgo Beach serial killer case and a ruling that could affect courtrooms nationwide. Defendant Rex Heuermann appeared in court alongside of his attorney, Michael J. Brown, for Wednesday's court hearing. The ruling allows prosecutors to use so-called advanced DNA evidence against Heuermann, specifically through hairs found on victims that allegedly can tie Heuermann to the crime scenes. Now, Heuermann is accused of murdering 7 women since 1993. The families of some of those victims were in the courtroom, along with Heuermann's ex-wife, Asa Ellerup. Now, Heuermann's defense team has been challenging allowing the DNA to come in, and they're going to challenge the decision the court made yesterday, saying that it violates public health laws because the lab that did the testing isn't even licensed in the state of New York. Let's talk about it some more. Fortunately, we know Michael J. Brown. Let's bring him on in for some questions. All right, Michael, so you, as always, have a backup plan. I think you have backup plans to your backup plans. And so you got this ruling, and then it was, okay, off to the races. You filed your own motion. Tell us what you're doing now.
Well, Julie, we were hopeful that we would get a favorable decision yesterday. We did not. So our backup plan was an additional motion. And this is something we brought up early on with the judge, and he said, well, put it in a separate motion as opposed to the Fry issue. And that's a motion to preclude the evidence simply based on a violation of the public health law. The public health law requires a clinical lab to be permitted, even if you're out of state. It specifically addresses identification procedures, and it specifically says if you're out of state, you can't even receive New York State samples unless you're permitted. And what the public health law does, interestingly, is it actually criminalizes that conduct. It makes it a Class A misdemeanor, which in New York State is punishable by up to 1 year in jail. So this motion now is predicated and focused on the fact that they have violated the public health law. It is criminal activity, and thus it should be precluded from being introduced to trial.
Michael, it's our understanding that this type of evidence that you're fighting over with the prosecution team has never been used before in New York State in a criminal case. Is that correct?
That's correct, Julie. The only case that we're aware of is in Idaho, which is what was called the Dalrymple case. And it was a cold case similar to what we're dealing with. And that's standard. The court did admit that type of evidence. And you have a lot of the same players in terms of the prosecution witnesses, our witnesses. But that standard is not the Fry standard. It's a different standard, and I would suggest it's a lesser, lower standard. But that's the only case that we're aware of where it came in an actual criminal prosecution in our nation.
Wow. Okay. Michael, I know that outside of the courthouse, there were some reports. As you know, this is a very high-profile case. Some reports said that you referred to this type of DNA evidence as magic. Is that accurate? What did you mean by magic?
Yeah, I have been referring to it as magic. The whole genome sequencing, there's two components of this, Julie. There's the whole genome sequencing, and once you develop this so-called profile, what are you going to do with it? And that's where it pivots over to the computer program that this Astrea in California does, and the computer program is called the IBD-GEM, and that particular program is what I will continue to call magic. It is highly unreliable. It is based on the Genome 1000 project, which is the alternate suspect pool, which there is no forensic lab that does a evidence sample to suspect sample across our nation. It's unheard of. It's never done. The prosecution's own witnesses said it's never been done, and that's where the magic comes into play, because the actual likelihood ratio, and that's the ultimate thing the prosecutor is trying to do, is throw these numbers before a jury to show them how overwhelming and astounding it is. That's the magic. It's unreliable. It's not credible. But of course, the judge differed.
Speaking of the prosecutor, Michael, I have a direct quote from the prosecutor out of court who said, quote, "We now have nuclear DNA. We have mitochondrial DNA. We have phone records. We have witness statements. We have financial records. We have internet searches. We have phone activity, and we have other evidence as well." Do you agree with that statement?
Well, they have an idea and a notion that they have different parts of evidence that they can introduce, but obviously, you know, that remains to be seen in terms of how credible and accurate these different things are. And really, a jury is going to have to weigh the weight of any of and all of these things. Yeah, they suggest they have a lot of different pieces of evidence. It's very circumstantial, but when you break down each piece of evidence and dissect it, it's far from strong. And that's why we have trials on the case.
Exactly. Michael, speaking of, is there a firm trial date set yet for this?
No, we haven't even gotten to that, Julie, because the next court date's September 23rd. There's two pending motions still. One is a severance motion because we're trying to separate this indictment from victims and not have everybody tried together, because some of them, quite frankly, should not be tried with the others. And then we have this public health law motion. And there will be subsequent motions in terms of suppression of evidence. But we can't really get to that point until the district attorney's office certifies the case for trial, and then our clock will run and we can go forward with these additional motions.
I got you. So a lot to tackle before any trial date is picked. Michael J. Brown, the best thing going for Rex Heuermann is you. Thank you so much for sharing what you could with us this morning about this recent litigation. We're going to hit a break. When we come back, we're getting ready for the closing arguments in the trial of Mama Donna Adelson. Live look at the courtroom right now. You can see we've got a packed gallery. If you look on the left there, you can see Dan Markel's parents. Remember, this is the fourth trial they have sat through, trying to get justice for their son. And on the opposite side of the gallery, you see support from Mama Donna with her husband, Harvey. He's been there every single day. We'll be right back with Court TV Live.
Matriarch of the Adelson family gets arrested. Terrible.
Donna Adelson is facing charges of murder, the death of her former son-in-law, Dan Markel.
Prosecutors say a bitter child custody battle was the motive for the murder-for-hire plot. Now that Donna has turned into a defendant, what's next for the Adelson clan?
Now that the ship is really sinking fast, blood doesn't matter that much.
The Matriarch Mastermind murder trial. Live coverage today, only on Court TV.
Welcome back to Court TV Live. We're getting ready to go into the courtroom and watch Mama Donna Adelson's trial. There are some amendments going on with the verdict form. Let's go in together live.
Do you swear or affirm the testimony you're about to give will be the truth?
Yes, sir.
You can lower your hand. Ms. Adelson, you understand that lesser included crimes are something that is available depending on what is charged as a crime.
I understand that, Colonel.
Do you also understand as well, if you waive your ability for the jury to make this finding, they can only make a finding as to what is charged first-degree murder?
Yes, that's correct, Your Honor.
In consulting with your attorneys, you understand the strategy of waiving all lesser-included crimes?
I do, Your Honor.
Is there anything that you need to consult with them further about concerning this matter?
No, there is, Your Honor.
Then may be seated. As to the jury instructions, I will remove second-degree murder and manslaughter as options.
Given that, Your Honor, I believe moving the two principal instructions directly after count one would also be appropriate.
We'll remove any reference from second-degree murder and manslaughter and principal instruction as well.
you get through with that, Judge? I didn't have one stop.
That's to change that thing that I'd like to consider. On principal instructions, the last line.
Give me one moment.
Okay, we've got a little pregnant pause in the courtroom. So while everyone is taking care of business, I have my legal analyst guest standing by to weigh in. They've been watching what just happened here. So apparently on this verdict form, there are some lesser included offenses with the crime of first-degree murder. So going back to the charges, there are 3 counts. Count 1 is murder in the first degree. Count 2 is conspiracy to commit first-degree murder. Count 3 is solicitation to commit first-degree murder. And Donna's defense attorney just asked the judge if they could remove from the verdict form the options of second-degree murder and manslaughter from the form. From under count 1 is what would be lesser included offenses. And Donna had no objection to that. The judge went through the little colloquy with her. Noted that it's a matter of strategy doing this. I've got Michael J. Brown and John Phillips. Michael, do you agree with this strategy as defense counsel to get rid of those lessers?
I do, Julie. You know, what that does is it gives the jury an opportunity to do really a compromise verdict. You have some jurors who are in favor maybe of acquittal. You have some who are stronghold on the conviction, and it gives them the ability to get that compromise verdict. But those are both very significant alternate charges, the murder 2 and the manslaughter. She's 75 years old. So what it does is, even if she was convicted of that, she likely will spend the rest of her life in jail. So it forces the jury to dig their feet into the sand and hopefully either get a hung jury or even possibly an acquittal. It doesn't give them the opportunity to compromise. So yes, in her particular case, I think it's a wise move.
Yes, and I think we may have audio of the defense attorney. Let's listen for just a moment.
The fact that principal applies to count 3.
The positioning of the instructions will be after, it will be introduction to homicide, count 1, count 2, count 3, principle 3.5 sub A, principles 3.5 sub B, intent, and then moving on to plea of not guilty, reasonable doubt, and burden of proof.
Yes, sir. And I see you have added 10, the language that was agreed to by both sides.
Yes. Right. As to the defense's request to move in certain portions of the 2023 and 2024 calendars under the rule of completeness, after reviewing this matter, the rule and cases associated with it last night, at this time, that is going to be denied, specifically as to the 2014 and 2023 calendars. These are not.
Okay, so Judge, going over some of what's in the jury instructions, what's coming in, what's staying out, cleaning up those last-minute things. John Phillips, want to go back to what we talked about when we kicked off opening statements this morning, the idea of her changing her mind. Do you think it's going to happen?
No, based upon the jury instructions and kind of where we're headed with closing out the evidence, it seems like there's either already been a little colloquy and they've talked about it, or he's just taking her, I'm not going to testify, as word and waiting on them to bring it up. But it looks like she's not testifying.
Yeah, I think you're right, John. It looks that way, because I would have thought the lawyer would have brought it up right away. I would think something like that they would have to, wouldn't you?
Yeah, absolutely.
Right away.
This is,
yeah.
You're waving now at this point.
Yeah, exactly. I think she's going to just be silent, and nobody on that jury can hold it against her. All right, so here's what we're going to do. We're going to hit a break. Michael J. Brown, John Phillips, thank you for the great analysis. Thank you at home for being with us for opening statement.